Order, order. I'd like to welcome you to the 16th meeting of the Joint Committee on Human Rights. And as the name of the committee implies, we comprise 12 members drawn from both Houses of Parliament, 6 from the House of Commons and 6 from the House of Lords, and from a variety of different political traditions. Today is our 16th meeting of this session, and we will be hearing from 3 witnesses as part of our inquiry into modern-day slavery and supply chain transparency. We've received over 800 pages of written evidence, and 20 of those submissions will now be published on the committee's website, with many more to follow as we near the point of writing our report and advising Parliament and the Government of our findings and our recommendations. Today we'll hear from Ms. Eleanor Lyons, who's the Independent Anti-Slavery Commissioner, from Mr. Alex Murray, who's the Director of Threat Leadership of the National Crime Agency, the NCA, and from Mr. Philip Holliday, who's the Central Regional Director of Border Force. Welcome, all 3. They will be helping us to delve deeper into the nature of modern-day slavery within the supply chains, the very things that feed into the commodities that we buy in our shops, in our stores, and online. During today's hearing, members will have the opportunity to analyse how the UK's current legislative and regulatory framework is responding to the risks of forced labour in supply chains and explore the potential impact of approaches such as import bans and mandatory human rights due diligence. The Office of the Independent Anti-Slavery Commissioner was established by the Modern Slavery Act of 2015. The Commissioner is tasked with encouraging good practice sharing amongst all those who have a role to play in tackling every aspect of modern slavery and human trafficking within the United Kingdom. The NCA is the UK's lead agency against organised crime, human weapon and drug trafficking, cybercrime and economic crime that crosses regional and international borders. It houses the National Economic Crime Centre, a multi-agency centre established in 2018 to deliver a step change in the UK's response to economic crime, building on the Joint Monetary Laundering Intelligence Task Force. Border Force is a law enforcement command within the Home Office and acts to secure the United Kingdom's borders and to oversee the entry of goods and people into the United Kingdom. Border Force carries out customs duties, searching for and confiscating goods deemed to be illegal or harmful. Now, none of these bodies, it should be pointed out, holds clear responsibility for addressing forced labour in supply chains, and the committee will explore how the duties to investigate and monitor forced labour should best be met, and whether new statutory approaches and new oversight might be needed. Let me say briefly something about our 3 witnesses. Eleanor Lyons, the Independent Anti-Slavery Commissioner, is the UK's independent commissioner established by the Modern Slavery Act in 2015 to encourage good practice sharing amongst all those who have a role to play in tackling every aspect of modern slavery and human trafficking in the country. And prior to becoming the Commissioner, Eleanor was Deputy Children's Commissioner, advocating and championing the rights of children in England, but particularly those that were vulnerable in care or in contact with social services. Mr. Alex Murray, the Director of Threat Leadership in the NCA, joined them as Director in September 2024. His role sees him leading the agency's modern slavery and human trafficking threat leadership team, amongst others. He is a former temporary Chief Constable at West Mercia Police, where he previously undertook both uniform and CID roles. He's also led teams in the Metropolitan Police, including cyber, modern slavery and human trafficking and online child sexual exploitation. Alex is experienced within both counter-terrorism and intelligence as a senior investigating officer. Mr. Philip Holliday, the Central Regional Director of Border Force, has responsibility for activity at all Central Region maritime ports, airports and postal depots. He has the national strategic lead on rail freight, fast parcels post and inland pre-clearance, and is the operations lead on digital passenger services. Philip's the Home Office national stakeholder, the lead with EasyJet and Ryanair, and on people matters, he is the Border Force Disability Champion, working for Border Force and its predecessor organisations for some 37 years. He's been in his current post since 2011. So let me begin with the questions, after which I'll turn to my colleague Dr. Peter Swallow to open up some questions on enforcement. But I'd like to ask, if I may, about protecting British consumers. And my first question is to Mr. Murray, and then I want to turn to Ms. Lyons. Is profiting from forced labour an economic crime against, or a crime against humanity, or is it both?
Thanks. Yes, I think you've banged the nail on the head, Chair. It's both. Clearly, it's an economic crime. What is the motivation behind people involved in modern slavery? Largely economics, either realising the value of owning a slave or treating someone unfairly and profiting from that. Similarly, it's clearly a human rights abuse of having someone's liberty taken away from them and everything that comes with that.
That's clear and sharp, and thank you very much for that response. Let me turn to Ms. Lyons. Do you think it's likely that goods linked to forced labour are being sold to British consumers in the United Kingdom today?
Sadly, I think it is the case that goods made with forced labour are currently being sold to consumers across the country. I think consumers themselves would be very concerned about it, but the owners cannot sit with them to make this change. I think we absolutely need businesses to show leadership in this space, and some of them already are. But alongside that, I think it's time also that the government acts to catch up with international partners and introduces new legislation to put in place more protections to stop goods being linked with forced labour coming into the United Kingdom.
Thank you very much. We'll delve deeper, if we may, into some of what you said to us already. But I want to turn now to Dr. Peter Swallow.
Mr. Murray, are existing legislation and statutory powers available to your organisation, to the National Crime Agency? Are they strong enough to allow companies and individuals to be held accountable for criminal activity linked to profiting from forced labour?
That's a very good question, and we largely operate under the Modern Slavery Act 2015, but also Proceeds of Crime Act. And the definition of money laundering, I think, is very helpful under Section 329, where anything that's been obtained from a criminal endeavour, such as forced labour or modern slavery per se, can be conceived as money laundering. So the legislation is there, proving forced labour in a supply chain, as you've seen in all your previous committees, and I've had the privilege of reading some of the notes from it, is very difficult to demonstrate, and that will always be a challenge for law enforcement.
And so in terms of making that easier for you, should the government be looking to reform the Modern Slavery Act or introduce new legislation or both?
So one of my team specialises in modern slavery, and they think the Modern Slavery Act is really progressive. They think it was groundbreaking, and I think to a large extent it was, and it was world-leading. Obviously, there's people here better qualified than me to comment on it. I think it's not necessarily the problem with the legislation, but the interpretation and the adoption of the legislation by all law enforcement agencies. So modern slavery can be treated as modern slavery, or it could be treated as different legislation controlling prostitution, assaults, all sorts of different things, and different law enforcement agencies will have different approaches to adopting that legislation.
Thank you. Mr. Sobel, I think, wants to ask you more about enforcement, and then we'll return to my colleague, Lord Murray.
Sure. So maybe this is one probably for you, Mr. Murray, and for you, Ms. Lyons, as well. So obviously we had the news overnight with regard that obviously some of the members of the committee were pursuing the GB Energy. So first of all, Ms. Lyons, do you feel that current enforcement of the existing legislation concerning the prevention of modern slavery in supply chains is effective?
So I think there are different pieces of legislation that aim to tackle forced labour in supply chains, and they're all touching different elements of the problem we're talking about. So of course we have the Modern Slavery Act, which 10 years ago, as Mr. Murray's mentioned, was world leading. I think it put the conversation in boardrooms. It saw businesses step up their gains to tackling transparency in supply chains, and actually we've seen responsible actors respond to it. I think, though, that piece of legislation, when we're talking about forced labour, lacks teeth, it lacks accountability, and I think we also haven't seen strong enforcement when it comes to making bad actors respond. We also have, of course, other pieces of legislation like the Procurement Act, the Procedures of Crime Act, but I think what we're missing is one overarching piece of legislation in this country which makes it clear that actually goods with forced labour will not be tolerated in the United Kingdom. When it comes to authorisation of it, I think enforceability does matter. So I really welcome the committee's work and the changes to the Great British Energy Bill. I think part of the amendments the government have made, though, what we really need to see now is that come to fruition and it to have a meaningful impact on them not sourcing goods made with forced labour.
So just on that point, so the government are going to put an amendment down that effectively means that GBNG will have to enforce measures to ensure that slavery and human trafficking is not taking place in its business supply chains. Do you think that will be effective?
I hope it will be effective. I think it's really important that this amendment has been laid. I think there's a job for all of us to hold the government to account on that amendment. And I think there is learnings we can take for other international partners in this space where they've had things like rebuttal presumptions and the kind of burden of proof does not sit on government and procurement officers to demonstrate that actually goods are made with forced labour. So I think it's a very welcome step and I hope it will make a big difference.
I think we've all been struck that the principal author of the 2015 landmark legislation, as it was then, Baroness May, Theresa May, has made it clear that she thinks that there needs to be a review and a reform of that act. Your view is then, to just delve a bit deeper into what you've just said, should there be a completely new act, or is it capable of Section 54 and so on being reformed? Maybe the insertion of rebuttable presumption that you've just mentioned. What more should be done?
In my view, at a big picture level, is the Modern Slavery Act is largely fit for purpose. It's a good piece of legislation. I think it has actually led the way and it's been used by the NCA and other partners to actually make a real difference in this space. There are some parts of the Act, though, such as Section 54 and the Transparency and Supply Chain section, that I think does need to be looked at again, and we do need new legislation in that space. So I think probably what we need is a whole new piece of legislation in the form of mandatory human rights due diligence to echo what we've seen in the EU and some of our other European partners doing. I wouldn't want to reopen the whole piece of legislation without looking at all the other sections of kind of victim support and making sure that actually it can still do its role in that space. But I think when we look at Section 54, that absolutely does need new powers, new teeth added to it in a legislative form.
Well, thank you very much, and thank you for being so publicly supportive of the all-party amendment that has now led to the government tabling their amendment in lieu of the ping-pong amendment, as it's described, that came back from the Commons. We are making progress, but it is incremental all the time, and it's therefore very helpful to hear from people like you telling us what really needs to be done next. But let me turn to my colleague, Lord Murray, to ask the next round of questions.
Yes, I just want to turn, if I may, the conversation to confiscation at the border. So this is a question in the first part directed at Mr. Holliday. To what extent could approaches for intercepting criminal property that's used at the border, such as for counterfeit goods, be used to confiscate goods linked to forced labour?
So at the moment there is no legislation which would allow us to do that. We work on behalf of HMRC in the Intellectual Property Office in regards to counterfeit goods. I think the important thing to draw out is when it comes to counterfeit goods, the value that Border Force brings there is we're obviously looking at goods which are quite clearly counterfeit. We're looking at the quality of the goods, and we can do that from physical inspection, whereas extending it to forced labour goods, the difficulty we'll always have is identifying how would we know by looking at a set of goods whether they are manufactured using forced labour. But at the moment, I say we know we don't have any legislative vehicle for forfeiture, and we wouldn't be able to use the counterfeit goods legislation for that.
The Proceeds of Crime Act, obviously, you could. There's an argument that could be advanced, is there not, that obviously modern slavery is a crime, and the goods the money made from the sale of those goods would amount to a crime sufficient to use those powers?
Well, it's interesting you should raise that because before the hearing I was chatting to my NCA colleague Mr Murray, and we were talking about the Proceeds of Crime, and indeed Border Force does use Proceeds of Crime Act when it's intercepting criminal cash outbound of the border. What we haven't previously used it for, and is around asset forfeiture and other goods that may be associated with crime. My understanding is that if we were asked to intercept something on behalf of another law enforcement body like the NCA, we would be permitted to seize those goods at the border.
At your moment, you would be more comfortable having some fresh powers rather than relying on existing powers. Is that really where you are?
Well, I'd say until I had this conversation with my NCA colleague this morning, I wasn't aware that this was potentially an option, so it's something we could consider.
So I might ask my kinsman, Mr Murray, to perhaps give us the NCA's view on that.
Yeah, well, this comes under, as we mentioned, money laundering legislation, and obviously you cannot own anything that's profited from a criminal offence of which labour or sexual exploitation would be. And so I think it's a legitimate position for us to go away and work with Border Force and HMRC to say, would this be a position that you could use at the border? And one thing that we do in the NCA is attempt to lead the system in the battle against slavery. So we bring all agencies together, we have performance objectives, we do a lot of operations that hopefully we'll have an opportunity to speak about later, and Border Force are members of that, so we can work through that, I think, with Border Force.
And to what extent do you think there could be identification of goods linked to forced labour derived from intelligence that you have, and then that's circulated to other authorities?
So that's a really good question, and again, if I refer back to the last session where you heard lots of evidence on how difficult it is to understand supply chains, particularly international supply chains, and how goods themselves can be laundered. And so if you have a widget from area A, has it been aggregated by a wholesaler in area B and then purported to be a legitimate item that then arrives at the border? There's not going to be an item that says this was made by forced labour, so somehow you need to deduct that it's been made by forced labour. So it's an intelligence question, and what I do know is that the Border Force Intelligence Agency, HOI, is very good at fusing data and making assertions and directing personnel, and similarly HMRC have got lots of capability in that space. So it would be a challenge, I think, for intelligence agencies, which people would try and get around, but it's a challenge that I think we should stand up to.
I think Mr Swallow's got a supplementary on this.
Yes, Ms Murray, I just want to ask for clarity whether those powers under Proceeds of Crime would be exercisable regardless of whether there was evidence of the use of modern slavery in this country and supply chains here, or in goods imported from overseas where there was evidence that in other jurisdictions that had been the case.
It's a good technical question. I'm tempted to say yes, just because when I think about the Modern Slavery Act, not POCA, the Modern Slavery Act obviously applies to any slavery anywhere in the world. And so you'd like to think the predicate offence, which is slavery anywhere in the world, as defined by the Modern Slavery Act, would therefore justify 329 of POCA, where you come in and say that is money laundering.
This is sort of untested ground, as it were.
No, it's not untested, it's just not in my brain. So I'd be, it may be untested, but it's a technical legal question that I'd need to get back to you on.
It would be very helpful if you could write to the committee about that, because we want to include a reference, I think, in our report. So thank you.
Yes, I will.
Just before we leave that, and I turn, if I may, to Ms Campbell, who's going to ask you some more questions around this question about financial reporting. Can I ask about the Proceeds of Crime Act that you've referred to? Because we heard evidence from Rahima Mahmood from the Uyghur organisations who had successfully gone to the High Court and won using the Proceeds of Crime legislation. So do we see that as an increasing route for the pursuance of people who are bringing goods made by slave labour into the United Kingdom? And secondly, has Border Force got sufficient capacity, not commitment, but capacity to deal with all these new routes that we're told are opening up using small regional airports using railway links across Europe bring goods in container lorries and so on. So it isn't just a question of theoretical supply chains. I mean, these are large amounts of goods. What kind of capacity do we have to actually track this stuff down?
Thank you, Chair. Just a small correction. I believe it was the Court of Appeal which made the distinction on what is considered by law a defence to 329 of the Money Laundering Act, which is adequate consideration, which means a good is not cleansed just because you paid a reasonable amount for it. And I really welcome that, by the way, and it's useful. So I do think that provides a lot of clarity for businesses on what adequate consideration is, which is helpful.
Thank you.
So thanks for that. And then my Board of Force comment.
Yes, Chair, and you raised an interesting question there in regards to there's two elements to the answer. One is around the competing priorities that Border Force currently has, and then there's also the practical realities, the logistics of applying these controls at the border. So on the priority side of things, we currently work on behalf of around about 20 different organisations at the border. Some of those are using our own powers, some are doing things on behalf of others, and some we represent others but they use their own powers, so it's quite a complex picture in itself. There's also a question around whether ports are necessarily the right place. They are a natural pinch point, and you can see the attractiveness and why ports might be chosen. But they are also very busy spaces, and there's a lot goes on in a port. But the other thing we need to be mindful of is the impact on legitimate flow of cargo, and that's always that tension we are operating within. Also, the way border controls are set up in the United Kingdom, you might recall back in 2009, the UK Border Agency was set up with a subset of HMRC. We moved across, 4,000 of us, to the Home Office to create the UK Border Agency, which then became Border Force, merged with Immigration Service. That was essentially to provide an operational feet on the ground, physical response to examinations of goods and people at the border. But HMRC have retained, they remain the customs authority for the United Kingdom. They retain the policy on customs. All import entries which contain the information about where the goods have come from, who the importer is, that also goes into HMRC. Some of the goods cross the border without a formal entry being put in, so it's often the goods come in under different, processes, like for input processing or various other reliefs. They get taken to a trader's premises, and then an import entry might be put in at that point. And so HMRC also do lots of work post-importation and lots of paperwork checks. So there's a question around, if import controls were appropriate, where would that best be placed, best be done? There is the power to seize in situ. So if goods get transported to a trader premises, government has the power to seize those goods in situ, which avoids problems around damages potentially being incurred at ports. It also avoids significant demurrage costs and the cost that ports impose on goods that are detained within the port environment. And then just swinging back to the original point around our priorities, like all government organisations, we are reducing in size. We have to make difficult decisions around our priorities. And we weigh up all these various priorities. There are things that we've had to turn down of late, whilst we focus our efforts on high threat, high harm stuff that's targeted on our border.
That's really helpful, thank you very much. Let me turn now to Ms Campbell, and after that we'll hear from Lord Delakia.
Thank you. My question is for Mr Murray. There is an established financial reporting regime where there's an obligation for relevant institutions to share suspicious activity reports, and these are shared with law enforcement in cases of suspected wrongdoing. Do you think, or could the SARS regime be extended to include cases of suspected forced labour?
Thank you. I think that's the questions for me. So it should do, and it does. So because it's a criminal offence, the UK FIU, the Financial Intelligence Unit, shares information with designated bodies to say these are the signs of human trafficking and forced labour that you should look for. And when you see it, please send us a suspicious activity report. and suspicious activity reports in relation to modern slavery and human trafficking come in every day, thousands of them every year, of which the UK FIU looks at, and then when they sense that there's a significant case here, they'll give to the relevant law enforcement agency. So training is given by the UK FIU to banking and other regulatory agencies on how to spot modern slavery human trafficking. Bit of a challenge because a lot of it's in cash, as we know, but I'm glad to say that thousands and thousands of SARs are given to us every year with modern slavery human trafficking as a marker from it.
Okay. So do you think using that intelligence would help us to reduce money laundering and disrupt that kind of criminal activity?
Yes, to a certain extent, and it has done, and we make hundreds of disseminations largely to police forces saying, here's a suspicious activity report, it looks like there's modern slavery going on here, please can you investigate? The real challenge, as many of us will know, is that for low complex modern slavery human trafficking issues, cash is king. And there's hawala banking, there's underground Chinese banking, there's things like exchanging goods. So, you know, I'll buy a nice watch and I'll take it and sell it in another country. So this is the challenge for us, and it's why, in actual fact, the NCA coordinated work with trading standards and police forces only in March last month to go and basically raid all sorts of high street establishments that we had suspicions on that are cash rich, that could be money laundering for any crime type, including modern slavery human trafficking. And in fact, across the country, 97 people were safeguarded who were potentially victims of human labour abuses. But money was seized, cannabis farms, and these are things like barbershops, vaping shops, you know, beauticians, nail bars, things that we've seen that deal in cash and that people can launder their own proceeds through in any case and exploit people working in them.
Thank you.
Thank you. Well, obviously there's a lot of money being made in this, and I think Lord Delarkia wants to ask you about that.
My question is also directed to Eleanor. Is addressing profit made from forced labour a proprietary threat under the NCA's strategic plan?
Yes, it is. Well, modern slavery human trafficking is a threat, both made clear to us by our Director General, but also by the Home Secretary. It's a primary threat that we deal with. So, yes, it is. Associated, the illicit finance associated with modern slavery human trafficking as an explicit adjunct to that is not. But with any investigation or priority area that we look at, like modern slavery human trafficking, there will always be a financial angle to it. So, for example, there's an example of a UK Nigerian nurse, I don't know if you recall this one, who was taking people from Nigeria and using them as sex workers in Europe, but she was profiting here, so the investigation was conducted by the NCA and £180,000 was taken from her that she'd made from that illegal criminal operation. So, although illicit finance isn't explicitly a priority for modern slavery human trafficking is. And as an adjunct to that,
thank you.
Illicit finance is associated with it.
Before we return to issues concerning potential solutions, can I ask Mr. Holliday a question about the UK's sanctions regime and whether perhaps that should be used against those who are engaged in selling goods linked to forced labour?
It's not an area I'm very familiar with. I'm sad to say. I know on UK sanctions we are looking at outbound strategic exports. We do manage controls on that. I'm not aware of how those powers might be used for inward bound goods.
Ms. Lyons, been able to give this any thought?
Are you referring to things like import bans, essentially?
Yeah, potentially, yes.
So I think import bans can be an important enforcement tool when it comes to tackling goods entering the United Kingdom with forced labour. I think it's something that the UK government should be looking at, and I've been speaking to them about it in role for the last year and a half. Which specific bit were you referring to?
I don't want to go deeper into that because I know that Sir Desmond Swain is going to ask you in a moment more about import bans. I was thinking more about the sanctions regimes generally that the UK has in place around individuals who are found to have committed various other crimes. Do you feel that this should be part of that package of things that could be done against people who commit modern slavery violations?
I think it's worth absolutely being looked at along the sphere of what tools we have to stop forced labour goods entering the United Kingdom. I think if we are going to tackle this problem effectively, we need to look at trade deals, sanctions, import bans, new legislation in form of mandatory human rights due diligence, and every tool that we can possibly use, because it's such a complex area that touches multiple different government departments and multiple government bodies' actions.
Thank you. We turn now to Sir Desmond, who will take this issue further, and then after that we'll hear from Baroness Lawrence.
Well, I was interested in this question of import bans and whether such a ban might actually make the plight of victims even worse. Is that possible? How would it be possible?
Yeah, so I think there's a lot of think that needs to go into preventing unintended consequences when it comes to import bans. I think one of those unintended consequences can be that we cut off a supplier and actually the workers lose out, a new supplier pops up and that one is used instead that may still have similar risks. I think there are ways around that though, however. I think when there's worker remediation built into import bans and there's strong structures in place, when initially they encourage businesses and suppliers to go and work closely with workers and to make sure that actually they're addressing some of those problems and those risk areas. I think on the whole, import bans are important when we're looking to have an enforcement tool when we need to make it clear that actually other actions have failed in this space. I think they're particularly important in areas where the state sponsored forced labour. And I think on the whole, actually, they can do more good than they can harm when they're effectively implemented. But if we look at other international partners, whether it be America or EU, they've obviously adopted different models for how they would go about an import ban. And I think there's stuff that we can learn from those different partners that we would maybe take forward in a UK piece of legislation.
So if we got to the stage of where we were going to have an import ban and you were going to have to enforce it, Mr. Holliday, what would be the implications, practical implications for your organisation and its resourcing?
I mean, the first question would be, who is best placed to manage this process? As I mentioned earlier on, the information on what the goods are and where they're coming from, assuming it's correctly declared, of course, goes to the National Clearance Hub at Salford, which is HMRC's import entry centre. They in turn apply profiles and they can identify entities of interest and countries of origin, places of origin. The question then is what value is added by, say, Border Force then examining those goods at the border, as opposed to the goods maybe being inspected by way of paperwork, looking at the paperwork, asking for proof of where the goods of origin, where they've originated and how they've been manufactured. As said earlier on, Border Force was set up where doing a physical examination would confirm or deny that something's of interest. So if it's an illicit substance, if it's cocaine or whatever, we clearly find it's cocaine. If it's counterfeit goods, examining it, we can confirm whether it's of the inferior quality, and we can make a judgment around whether that's counterfeit goods. If it's from HMRC perspective, if we think the goods might be misdeclared, we can examine the goods to see if they're declared correctly. Their description, does it match what's on the import entry? When it comes to this particular subject, I say that the question then comes, is the best way of enforcing it by Border Force to examine the goods? What more would we gain from doing that? The challenges you then have is by examining the goods at the border, you add to the volume of interventions that are already being carried out at the border. And it's not just by Border Force, it's by plant health and animal health and all the various other organisations that operate at the border. If we come then to, say, seize the goods, how do the seized goods get stored? There's then the associated costs which the ports impose on the importers whilst they are being stored. So the constraining factors are, one, around the examination facilities. the amount of infrastructure that's available in ports is quite limited. So the competing demands for all the various agencies. And I said, the bottom line question was what is the optimum way of confirming the origin of the goods? It probably isn't a physical inspection of the border. It probably is, I say, looking at the paperwork, identifying individuals of interest through the paperwork as opposed to examinations.
So clearly, examining it isn't going to tell you how it was made, or unlikely to. So you'd be looking at some sort of intelligence resource. Would that be the National Crime Agency?
Well, yeah, how do you determine where something is from and whether it's from human trafficking or labour abuse? So that's the question. And as you've seen from previous testimony here, it can be scientific, DNA related, which itself is often quite contested. Does it come from this part of this world? Where you may say, for example, the majority of goods from here are from forced labour, or otherwise we have to work back and understand how does this supply chain operate, which would be an intelligence operation, either for Home Office intelligence that serves Border Force, for HMRC intelligence, or indeed for NCA that also has intelligence officers.
So would it be fair to say that an import ban is far from straightforward?
I think it's fair to say that it's far from straightforward. However, I do think we have seen it operationalised in other countries. I think it's obviously resource intensive, as we've heard from Border Force, although we have seen where it works well, like with the CBP in America, it's because it also works in conjunction with listening to law enforcement, with listening to NGOs, with data sharing, with kind of partnership with other organisations that can help support the work of Border Force. I think it's a big ask for Border Force to be able to do alone. And I think it does also need to be complemented with other measures such as corporate accountability, strong labour market enforcement domestically. But I think it is a tool that actually this government should be looking at potentially moving forward. I think we also need to ask ourselves the question, if the EU and America are doing this, we do not want to be a dumping ground for all the goods that are not going into those markets. So I think it is something that we do need to look at.
Thank you. Baroness Lawrence has got a supplementary on this, and then we'll hear from Mr. Afzal Khan.
Yes, you've answered part of my questions already, so I'm just going to go to a very short one. How could an import ban be resourced and enforced, for example, from penalty charges to corporation and importers? So that's to Mr. Holliday.
Sorry, your question was how could the import ban be reinforced with penalties?
Could be resourced and enforced through penalties, penalty charges to corporation or importers? It's a great question. Probably not one for me to answer. Maybe for the Department of Business and Trade is possibly someone who may be able to answer that, because I think they have been looking at penalties, but it could potentially be a revenue stream, potentially to offset. That's all I can advise, really. I've got no expertise or knowledge of this area. Other colleagues give any...
So I've spoken to the Department of Business and Trade about kind of what penalties could be in place when looking at the issues of import bans. I think there's a general reluctance to introduce them due to some of the constraints that we've spoken about. But I think what they are useful for is making it really clear to companies and businesses who are bad actors, potentially, or have forced labour in their supply chains, that actually this is unacceptable practice. Obviously, one of the things that businesses do respond well to is charges against their bottom line. So I think actually that is why that measure of having penalties in place can kind of complement an import ban. We have seen some of our other partners look in this area and have some penalties in place. And I think actually the reason that stuff like money laundering is taken so seriously by businesses is actually they do understand at a corporate C-suite level actually some of the consequences of having money laundering within their business and the consequences. I think the challenge we have when we're talking about forced labour is actually there's not as clear a consequence for businesses in this space. And actually, I think that's what needs to be made really clear from the government, that actually it's unacceptable as practice. I will caveat that though by actually I have worked with some businesses who are leading the way in this. They go further actually than the government asks them to. And of course they have international supply chains and are affected by international legislation, so are actually going above and beyond what the United Kingdom and the legislative framework currently demands.
Thank you. Mr. Murray, have you got anything to add to that?
So, I can't comment on import bans, but I can provide a parallel insight. One of the threat areas I look at is firearms. And we've demonstrated that a type of firearm called a top venting blank firearm, a blank firer, can be easily converted to become a live firearm, therefore it's illegal. And so we've spoken in the firearms world to the importers saying you're now importing illegal firearms, and if you continue we'll prosecute you, and they've stopped. And all those illegal firearms coming into the UK that are easily convertible are no longer coming into the UK. So it's a parallel insight, but whether we should have bans and what the capacity and the punishments is probably, as my colleagues have said, not for the NCA to comment on.
Thank you.
Thank you very much. Mr. Khan, and then we'll hear from Mr. Tom Gordon.
Mr. Lyons, in your view, should the UK impose mandatory human rights due diligence on British companies? And if so, should this apply to companies of all sizes, or should the UK follow the EU's approach of the big companies only?
So I think the United Kingdom government should introduce mandatory human rights due diligence. I think in my mind this is the bare minimum in terms of new legislation that we need to tackle this issue of forced labour. As I've outlined, actually, I think lots of businesses and lots of leading businesses actually are calling for this too. I work with businesses who actually want the government to introduce this legislation. They want there to be a level playing field and for their efforts tackling forced labour in their supply chains to be acknowledged, and for those who aren't doing it to address those problems within their supply chains. I think it should be applicable to businesses of all sizes, including SMEs. Again, I work with SMEs who would welcome that legislation as long as it is proportionate, risk-based and in line with the UN guiding principles in this space. I think the EU's approach to phasing in the legislation is the right one, so they are going after big companies first, and then there will be legislation applied to the SMEs 2 or 3 years later. So I think that is the right way to go about it. But absolutely, I do think we need this legislation, and I think we're behind in terms of having it in this country.
Thank you very much. Mr. Gordon.
Thank you. It's to Mr. Holliday. So how has a newly enforced Procurement Act impacted on your own organisation's procurement activity? And following on and building upon that, has any training been given on how the Act should impact organisational decision-making?
In short, that's not my area of expertise, as I'm here representing Border Force operationally. I know within the Home Office that Act has been enacted, but I'm not cited, I've got no briefing on how it's been applied within the wider Home Office. Sorry. It's just not my area of responsibility.
Well, perhaps before we turn to Baroness Lawrence, can I just press you on that? I was involved in amendments to the Procurement Act at the time, and particularly the impact that it could have on issues around modern slavery. Would it be possible, in perhaps returning to the point Mr. Gordon has made to you, to perhaps write to the committee subsequently, if you can establish any information about how the Procurement Act has impacted on the work of Border Force, or indeed might add as well to the NCA, whether you've noticed any significant differences that have occurred since enactment?
Yes, sir.
Thank you.
And in the NCA, our procurement department have done quite a lot of socialisation to the wider NCA around what's changed and what's required. So intranet presence, knowledge videos, which have demonstrated what the Procurement Act is, what it's here for, the simplifications required to ensure that we don't have forced labour in our own supply chain in the NCA. And the government, in fact, have got quite a few good knowledge drop videos in relation to the Procurement Act, which is useful. So.
That's helpful to know, thank you. Baroness Lawrence, then we go to Mr. Sobel.
My question is to Ms. Lyons. Will public procurement decision makers be able to implement the provision of the Act effectively? For example, the new discretionary exclusion criteria, which enables company to unethically practice to be excluded from tenders.
On the Public Procurement Act?
Yes.
Yeah. So I think it's really important, obviously, that public procurement is free from forced labour and the supply chains. I think that was one of the things that was missing from Section 54 of the Modern Slavery Act. It's obviously only recently been commenced in the last couple of months, so we await to see the impact of it. But for me, I think one of the really big learnings from the Modern Slavery Act is actually how things are enforced and applied as legislation really matters. I have read the provisions in the Procurement Act that apply to modern slavery and human trafficking and the policy notes that go with it. I think I have some concerns about the clarity and how easy it is to understand as a procurement officer what steps they should be taking. So I have concerns that, for instance, it's discretionary whether a business or supplier should be disbarred. I think it should be mandatory if we find there's evidence of forced labour in supply chains that actually they cannot supply to government or public bodies. They also speak about elements such as self-cleaning. I don't think it's clear what self-cleaning looks like for businesses in my mind. And I think it's actually putting quite a big burden of proof on the procurement officer to make those decisions. So I think a couple of things need to be done. I think obviously we need strong training that we've heard the NCA has in place. I think the guidelines in terms of the policy notes need to be clear. And I think actually there needs to be strong leadership from government and the Cabinet Office and the Procedural Review Unit that actually complements how the Procurement Act is now rolled out for it to have kind of a meaningful impact in this space. So in my mind, it's a wait to see how effective it is, but I think actually at the moment, I think we are lacking some clarity in this space. I would also say there's some elements within it, such as there has to be a criminal threshold of modern slavery and human trafficking. I think that's all well and good, but at the moment, like the prosecution rate under the Modern Slavery Act is around 2%. It's not easy to demonstrate a criminal threshold of forced labour. We've heard about the complexities in supply chains. So again, that's quite a high bar for disbarment when it comes to that act. And that's something, again, that I would potentially want to keep an eye on, and I will be in role. Following on from that, you've mentioned some of what you think that should be done. What can be done to ensure the Act's new provision are used to deliver an effective impact? What would you suggest that the government needs to do to make sure that's done? So I think the ultimate thing the government needs to do in this space is show really strong leadership and accountability. I'm really pleased that the government has now made changes to the Great British Energy Bill and accepted those amendments, but I think it needs to be clear as an absolute baseline that actually the government does not want in any of its public procurement goods made with forced labour. And I think this sits within the Cabinet Office's remit. We need for the CDL to be taking real leadership in this space and making sure that kind of the Procurement Act and the rollout of it is a priority for that department.
Thank you.
Thank you. I think we'll return, if we may, a little later on to this question of who takes the lead and what they need to do about it. But let's go to Mr. Sobel.
So, Mr. Murray, obviously data intelligence sharing are really crucial to stop the flow of these sort of illicit goods into the UK. I know in your Manchester office you host a branch of Interpol which works in this area. Do you feel that there is ways to improve collaboration, supply chain data and intelligence, firstly to provide information to companies and the public around flow of goods that may involve forced labour, and secondly to identify wrongdoing at domestic and international level?
Thanks. Yes, so the UK FIU is part of the Egmont group of FIUs that operate in 170 countries around the world, and is probably one of the busiest FIUs for passing intelligence to and receiving intelligence from other countries on all criminality and finance associated with it, including modern slavery, human trafficking. So, and the amount of requests we make of Interpol and Europol and them of us is significant. So I'm pleased to say we do share an awful lot of intelligence. I think your point was less about intelligence sharing around modern slavery, human trafficking, more about supply chain. And you're right, I think because of the opaqueness of supply chains, we are not, the amount of intelligence that comes our way is not abundant around this is a supply chain which has labour in it. And in fact, when it does, rapid action is taken. For example, you may have heard, I think it was the end of last year, Cambridgeshire Constabulary did a great operation on people, forced labour within some well-known fast food restaurants. And in actual fact, those fast food restaurants were employing people perfectly normally, but they were being coercively controlled by an individual back in a flat where all their money was being taken from them. And Cambridgeshire was able to respond and eliminate forced labour from that supply chain, if you like. But it feels quite rare where you say this is a supply chain where you can demonstrate, on a balance of probabilities, there's something nefarious going on. But I think whenever that sort of intelligence is received, it should be acted on and communicated far and wide.
And what are the typical limits on data sharing, for instance, through GDPR security concerns? Are people enacting forced labour either domestically or through the supply chain, utilising our laws to hide it? Do we need to improve data sharing?
Yeah, so it's a good question. Obviously, there are exemptions when crime is taking place from a GDPR point of view. But there's a huge amount of industry, both in all law enforcement agencies and businesses, ensuring that you are data protection compliant, and that can add inertia in the system. And law enforcement used to say dare to share, but law enforcement are also really concerned about breaking the rules because they're there to enforce the rules. So I think there's probably a cultural reticence because of fear of breaching data protection acts that is unnecessary because there are exceptions in the Data Protection Act for sharing on crime. And we should, and companies should, whenever they suspect nefarious activity, be telling law enforcement, and we should be telling other countries. And I think to a large extent we do. It's a very good question to say, do businesses, if they suspect that there is forced labour in their supply chain, what do they do? And I think as we heard earlier, there'll be good actors, then there'll be the willfully ignorant, and then there'll be bad actors. And there'll be a complete spectrum in all industries as far as that's concerned.
Thank you. Many of us followed the work you did in Cambridgeshire and full of admiration for the successes that have been secured there in exposing what was being done and helping some of the people who were victims and now survivors of modern-day slavery. And that's the issue, I think, which Ms Campbell wants to return to.
Yeah, may I just say that was Cambridgeshire Police. Brilliant work by them, not the NCA. I wouldn't want to take credit for that.
Take credit where it's given and not where it's
given. Thank you very much.
Thank you.
Brilliant work anyway. This is a question for Ms Lyons. How do you think a Survivor Advisory Council would benefit development of policies in this area?
So I think this is a really important thing that needs to happen. We absolutely need to have a Survivor Advisory Council established in this country. I think that's really important because some of the legislation we've been speaking about is focusing on the harm once it's happened. We really want to be able to prevent some of this harm happening. I think one of the best ways to do that is to listen to survivors themselves, to understand what led them to being in this situation of forced labour and some of the help and care and support they would have wanted as part of their recovery journey. This is something that our international partners do, and they really want us to do it. It's something that survivors themselves have told me that they want, and I have put in a business case to the government that they need to establish a Survivor Advisory Council, and I really hope that they do take it forward.
Do you anticipate that the business case that you submitted to the Home Office for a Survivor Advisory Council will be successful?
I hope it will be successful, and I will say that I've spoken also to the Foreign Office about this space and other wider government departments, because I think it's absolutely critical that we hear workers' voices and that we make sure that we're remediating them as part of any action that we take to tackle forced labour. So I would appreciate any efforts that anyone can make to encourage the government to establish one.
What would you think would be any barriers that would prevent that happening? So the importance of the survivor's voice.
So I think one of the barriers that I'm currently coming across with government is that I think it's really clear from survivors themselves and from the OSCE and other partners that I've spoken to that survivors rightly want to be remunerated for their valuable contribution to a panel. I think the government is currently a little bit reticent about how they would go about doing that, but I think it's really, really important that there's a trauma-informed panel established, that the valuable contribution that survivors make is recognised, and I think that shouldn't be a barrier to the establishment of a panel.
One final one. You've said that people, international agencies have done this.
Yep.
How have they overcome those barriers?
So we've seen in America the former Trafficking in Persons ambassador Cindy Dyer done it, and so has the OSCE Carrie Johnston. They've overcome these barriers by making sure they establish panels which offer remuneration and pay to survivors, that they have a really clear remit, that there's really clear kind of guidance to survivors and fair and open competition with applications, and that also the survivors understand that their work is meaningful and they're leading to a bigger change. Every survivor that I've spoken to in this space wants to make sure that they're helping others who may still be in horrific situations of forced labour, and they want that opportunity to help create change and be part of legislative change, policy reform, and I think it's completely right that we give them that platform.
I got the distinct impression that you would like to encourage the committee in its recommendations to support the establishment of the Survivor Advisory Council. So if after the hearing is over, if there are further points you feel that we could usefully make, then please feel free to add to what you said to us today.
Thank you. I'm pleased that came through.
It did, very successfully. And as I said, take credit even if it belongs to others. Now, we've got two more questions on the issue I said we return to about leadership. And I'd like to invite Mr. Khan to start with this and then Dr. Swallow.
The question to you, Mr. Lyons, again, you've got a good share of your questions there. Where should the ultimate responsibility sit for ensuring that the UK market is free from goods linked to forced labour?
So I think it's a case of we need to all take responsibility in this area. I think the kind of two main actors that I speak to is we need clear leadership and responsibility from government in this space. There needs to be clear legislation and a clear framework for businesses to abide to. And we also need businesses in this space to make sure that they're looking at their supply chains and really looking at what they could do to prevent forced labour occurring and then address risks in their supply chain. I think consumers do care about this space. I don't think we can put responsibility on consumer actors, but I think from everything I've seen, consumers do respond to wanting goods to be made without forced labour. They want to be able to trust businesses that they are buying goods that are being made in an ethical way.
And to Mr. Murray, how could a cross-government approach, including the Home Office, the Department of Business and Trade, the FCDO and the DESNs, be aligned to address the issues of forced labour in supply chains?
Well, that's a really good question, which I don't feel massively qualified as an NCA operative to answer, albeit I think this committee in itself is indicative of a great response cross-party approach where I hope your recommendations are taken very seriously. I think leadership is also very important in law enforcement from a modern slavery human trafficking point of view, because more often than not it's a crime you have to uncover and then work very hard to keep your victims with you. Picking up on the victims point that you raised earlier, and that takes discretionary effort when there's a lot of demands on your time. So from a value-based point of view, senior police leaders and law enforcement officials across all the agencies also need to demonstrate leadership and to a large extent have, and we have seen increased prosecutions, albeit at a very low level over the last 10 years.
Anyone else?
In terms of where leadership should sit across government?
Yeah.
Yeah. I think this is a big issue, and I think it's part of the reason that we're seeing kind of a lack of clarity in areas about what the UK is doing to tackle forced labour. I think there needs to be clear leadership from number 10 and Cabinet Office at a bare minimum, but we have Home Office owning the modern slavery policy and the modern slavery statements. We've got the Department of Business and Trade owning Fair Work Agency, single enforcement body trade deals. We've got Foreign Office owning soft power. And when I speak to all of these departments, as I do on a regular basis, often they don't know what's going on in the department next door. I think there needs to be a clear strategy laid out by government about what they are doing in this space, and I think it needs to be owned by the absolute leaders in government, number 10 in Cabinet Office, because I think this is one of the areas where individuals' human rights are being affected, and that is kind of a baseline expectation of government that they should be putting protections in place, in my mind.
Thank you very much. I think you were mentioning, all of you, in fact, the international collaboration and cooperation that is required to tackle this effectively. And I know Dr. Swallow wants to ask you about that.
Yes, thank you. Mr. Murray, to start, if that's all right, which global bodies and institutions is the UK engaging with to address the issue of forced labour and supply chains? You've already mentioned Interpol and Europol, but are there others?
Yes, well, within Europol, there are different subsets of agencies, and one organisation is called Impact, which we are part of, and we actually lead the modern slavery part of Impact in relation to online issues, particularly associated with adult sex work sites, and also some of the illicit finance side associated with modern slavery, human trafficking. So those are obviously very important. Then we have very close relationship with Five Eyes communities, and bilateral relationships also strong through the NCA. We have a very strong network of international liaison officers in the NCA across the majority of significant countries where this would be an issue, and that allows for good bilateral relationships and engagement, as well as Interpol and Europol.
And NGOs and others working in this space from a sort of a human rights perspective, are you working with them?
So we have relationships with those NGOs, and my modern slavery human trafficking team has relationships. They're not formalised in a way that they were 3 or 4 years ago, where there was a whole series of very strong networks, which I think have somewhat disintegrated, but you're probably better qualified than me to say that. But there are many, many NGOs in this space. I've been out to Cambodia with police officers, with Hope for Justice, for example, a human trafficking organisation that campaigns against human trafficking. So those, they do exist, and we have those relationships. They're not as formal as you might imagine.
Ms. Lyons, perhaps you could add to that.
So I think in my role, I work with a lot of international partners, because I think it's really critical in terms of our efforts to tackle forced labour. This is a global problem. It's affecting everyone in this space. And I think one of the kind of sad advantages of us falling behind in this space is actually there's a lot of learnings that can be taken from how other countries have chosen to introduce new legislation and which things they would take forward and encourage us to do.
That's please expand
on it. So, for instance, I think when it comes to mandatory human rights due diligence, we've seen it applied at a national level in France, Germany, the Netherlands, and now it's at an EU level. I think actually we should be looking at introducing that, and actually we're behind. It comes into power officially in 2027, so we need to act now to make sure that we're catching up in that space. When we talk about import bans, the EU is again doing that, and America has been doing that under the Uyghur Forced Labour Prevention Act. I think that's again a space that they would encourage us as a country to look at and make sure that we're echoing some of the legislation. When we were talking about some of the challenges of import bans earlier, for instance, we can look at the EU model, whether we'd want to do it kind of product by product with import bans, or whether we actually think a rebuttal presumption like America is better route forward. So I think kind of that strong international partnership and working is something that's really important in this space.
Thank you. I mean, there'll be a moment at the end for a roundup of all three of you to give us your couple of asks, if you had a wish list of what you think would be the most important things we could be recommending, and perhaps if you want to include that as one of your priorities, I'm sure we'd be happy to engage with it. But you mentioned earlier on that if we don't act, then we could become a dumping ground as well for other countries. But you also were very praiseworthy of those companies that you said have a higher standard even than the law requires. And I personally felt very encouraged by that, which begs a question to my mind, if I may ask Mr. Murray from the NCA. How common is it for you to receive tip-offs from companies and corporations who are concerned about forced labour in their own supply chains? And would the NCA want to encourage more of that sort of reporting?
Unfortunately, I think it is uncommon. We do receive referrals and we then decide whether we're going to investigate, and we have a tasking mechanism where we would ask a force to investigate when we receive that form of intelligence. From actual companies themselves, it's a rare occurrence, but from whistleblowers, from victims themselves, that's where a lot of, or advocacy groups or people on the ground who are advocating for those individuals, that's often where we receive, and forces receive those referrals. From businesses, less so.
Okay, that's really helpful to hear that. But I think Mr. Sobel wants to come in, but Baroness Lawrence caught my eye first, so...
Yes, it's follow on from what Ms. Lyons was saying about other countries who are so far ahead and we are just not really there. And I think for me, I was thinking about what sort of recommendation would you give to us as a committee to put forward to the government if you believe that we are so far behind, because 2027 is a couple of years ago and things are happening now. What would you suggest?
For me, I think the thing that we need as a bare minimum is mandatory human rights due diligence legislation. I think that's something that absolutely needs to be introduced on the kind of statute books. We saw, of course, Baroness Lola Young's private members bill last year in this space. I think that is what's needed to make sure that we have at least the signalling as a bare minimum that it's unacceptable to have goods entering the United Kingdom that are made with forced labour, and that we're encouraging also businesses to look at prevention in their supply chains as well as looking at risks. At the moment, the Modern Slavery Act asks individuals to report on things that have already happened, but we need legislation that incentivises businesses to be clear about what they're doing to prevent goods being made with forced labour. And we also need there to be a level playing field so that actually good actors are rewarded, good businesses are rewarded, and that we encourage other businesses to kind of up their game in this space. That would be my main recommendation.
Thank you, Mr. Sobel.
So following on from that, so thinking about the debate we had on my amendment, on Sarah Champion's amendment on the GB Energy Bill in the Commons, one of the points, both in the chamber and privately, that the minister made was that GB Energy was too narrow, which we generally agreed, too narrow a vehicle to stop forced labour and solar supply chains. And what the solution that was posited, which still is a solution, so this is what I want your view on, was that we should use the Procurement Act 2023's debarment list to debar companies where it's been identified they use forced labour in the supply chain from supplying the whole of the public sector. So it'd be useful to hear your view on that approach, but also that's obviously just public procurement. And the previous answer, that's a much broader scope. So do you think that updating the legislation, we should also be using debarment list, or do you think that will be superseded if we do have new legislation?
I think you've touched on a really critical issue, which is we've got the Modern Slavery Act, we've got the Health and Care Act, we've got the Procurement Act, we've got lots of different pieces of legislation at the moment that are doing different things, whether it's asking companies, private companies, to publish modern slavery statements, whether it's the Procurement Act with kind of a discretionary debarment list, whether it's the Great British Energy Bill looking specifically at things that they're going to procure in that space. I think what we're missing is one clear overarching piece of legislation across businesses, public procurement and wider organisations that makes it clear what the expectations are for goods not entering this country made with forced labour. And I think the reason that matters is because with each of these pieces of legislation, how they're enforced and how they come into practice does matter in terms of their impact. And actually, each of these pieces of legislation, whether it's the Health and Care Act, looking at the NHS, actually you have regulations, they're rolled out, they need to be understood and applied. Then you have the Procurement Act, and that needs to be done for procurement officers. I look at kind of local authorities across the country. Most of them actually are unaware of some of the provisions that are in place. And I think with each new bit of legislation, I welcome it. I think it's going in the right direction. But legislation needs to be more than a signalling tool and needs to actually be put into practice. And I think that's kind of the challenge we have by it being in different pockets at the moment, in my mind.
Thank you very much. Well, you'll be relieved to know we're coming to the end of the session. First of all, thank you very much indeed for the contributions you've made. They've been wonderful. You realise that we've got to now distill everything that you've been saying to us today and everything we've heard in previous oral sessions, but also 800 pages of written evidence, into some reasonable recommendations to the government. If you were in our shoes and you could just have a wish list of a couple of things, what would be your priorities? And I'm going to start with Mr. Murray, then Mr. Holliday, and then, having given Ms. Lyons a short breathing space between her last replies, to just distill into a couple of short, sharp points what you would be urging us to do. Mr. Murray.
So I can't underestimate the importance of shining a light on this issue. And it's one of cultural awareness across business, law enforcement, politics. And so rather than a specific legislative requirement that might come from Ms. Lyons, for me it's a case of amplifying the fact that this exists. We need to keep our eye on it, we need to do more, and we need to focus on it. So it's one of government narrative, I think, and public narrative.
Thank you very much. Mr. Holliday.
With me, it's about trying to anticipate the challenges with whatever approach we propose. So, for example, we've talked earlier on about supply chain and how opaque that is, how difficult that is to prove. So whatever we can do to sort of heighten that and bring that to the fore in whatever proposals are made is one area. And then also linking, something I didn't cover in my evidence was around anticipating the challenges to seizures that will be inevitable. And just last week, I concluded a case in the High Court. It's a 10-year case where someone challenged a seizure we made at the border. They were claiming damages of 7.75 million. We were initially supported by the Magistrates' Court. They said it was a good seizure. The Crown Court supported us, and so we destroyed the goods. The High Court disagreed and said to the importer, no, you can have your goods back. We destroyed them. So we just need to anticipate how these things might, the unintended consequences and where it might go. So, you know, the thing about, was it rebuttal presumption, for example, might be one measure if we were making recommendations where the onus is put on others as opposed to law enforcement, because as I said, otherwise we'll be on the back foot the whole time trying to A, argue about the supply chain, and B, that they were goods that were correctly subject to forfeiture. And then when it comes to standards of proof, as we all know, the different standards of proof when it comes to criminal and civil proceedings, you know, maybe that's also something we need to look at, what the standard of proof, where it might be a sort of a lower standard of proof if we think that civil action is the right way forward, but that still sends the strong messages around, you know, your goods may be subject to forfeiture. So I'm just looking through this the lens of someone who's recently lived and breathed it, and also trying to anticipate how government broadly would enact any changes moving forward.
That's very helpful. We have had quite a lot of evidence about experience from the United States on rebuttable presumption. And if there's further information you want to share with us after the committee's meeting is over, then feel free to add to what you've just said. Thank you. And the last word, please, Ms. Lyons.
So I really welcome the committee's focus on Sarah. I think it's critical. I think we need the government to be encouraged to take clear leadership in this space, and at a bare minimum introduce mandatory human rights due diligence legislation. And I think any solutions need to include survivors' voices and worker remediation as part of that package. And I would really welcome survivor advisory panels being established as part of the kind of policy-making legislative framework.
Thank you very much indeed. So let me repeat my thanks to each of our witnesses today for sharing their extraordinary expertise and their wisdom with us today. It's been greatly appreciated. We will be having what I think will be our last session on this issue, oral session, and that will be on May the 7th, when we hope to have a ministerial response from the government, and then we will get on to the drafting of the report and recommendations to the government. Be interested to know that the Lord Chancellor, Shabana Mahmood, will be the Lord Chancellor. Shabana Mahmood will be here to give evidence to us, and we will be asking her around a lot of the issues that we've been discussing over the preceding Wednesdays when these sessions have examined a whole range of issues. But we will also be asking questions around modern-day slavery and human trafficking, so a further chance next Wednesday will also arise. But with those words, it just falls to me now to conclude our proceedings to say, order, order.
Thank you.